inspector with the Federal Protective Service, the Department of Homeland Security, a solid patriot, Richard became a student of the Constitution. Seeing the abuses of the government from an insider's perspective, decided the people needed to know the truth, authority granted to government by our founding fathers.
Yes, and we want to thank Richard. He drove all the way from Houston, Missouri tonight, this afternoon. He's going back tonight, so we want to thank him for coming. I also want to tell you he's got books for sale back here. They're $20 each, and I have started it, and I love the opening. I love the opening, how you talk about, well, you're going to talk about it. Anyway, it's a great book there. All right, any questions, concerns, anything else?
Thank you, Jan. I appreciate that. This presentation usually takes me about 2 hours to complete. I don't have that much time, so I'm going to be skimming through a lot. I stay with this presentation because there's a lot of things that I talk about or I teach that are contrary to what you've learned before and probably about things that you believe. So I like to give proof and evidence to give cooperation to what I'm saying. So before I go too far, a little bit of myself. Like you found out, I was with the Federal Protective Service. I've been in the federal side of law enforcement for 23 years. I started off as a security police officer in the Air Force. In '91, I moved to the Treasury Department. I got a job with the Treasury Department with the Mint. And at that time, I had to go through the Federal Police Academy, as you would expect. And as you would expect, they had a very intensive course on the Constitution, constitutional law. And at that time, they were taught us that the Constitution outlined the 4 branches of government. That the legislative branch was the most powerful branch of the government because it had the power to make laws. The second most powerful branch of the government was the executive branch, the presidency, and his job was to enforce those laws. And the weakest power of the government was the judicial branch, our Supreme Court and judges, and their job was to uphold the law. They also talked about that time about the state being sovereignties of themselves, but had a symbiotic relationship that was so important to make their government as perfect as can be. Now, in 1996, I moved to the Federal Protective Service. Because I had not gone to the refresher course, which was mandatory every 3 years, I had to go to the academy all over again. This time when I went through the academy, they were teaching about the Constitution was not as intensive. And they were teaching that there were 3 equal branches of government and that the Constitution only had some restrictions on the state government and there wasn't much more. Obviously, this is the complete antithesis of what I learned the first time. As a federal police officer, you are sworn to uphold the Constitution. So which version of the Constitution would I uphold? So I started an investigation to find out. And this presentation, my books, Dark Side of America and Constitution Made Easy, are the result of my investigation. Now, before I go too much further, I'm going to ask a couple of questions. And the first question is multiple choice. It's this: what are the supreme laws of the land? Is it A, the Constitution and the Bill of Rights? Is it B, the Declaration of Independence, the Constitution and Bill of Rights? Is it C, the Declaration of Independence, the Constitution and all legal laws made under the Constitution? Or is it D, the Declaration of Independence, the Constitution, the Bill of Rights, and all legal laws made under the Constitution? Can I get a hand to how many people think it's just the Constitution and Bill of Rights? Okay, how many people the Declaration of Independence, the Constitution and Bill of Rights? Okay, got a couple there. How about the Declaration of Independence, the Constitution, and all legal laws made under the Constitution? How about D, the Declaration of Independence, the Constitution, the Bill of Rights, and all legal laws made under the Constitution? Okay? Now that I figure out how to change this. What you see here is a display. You'll find these displays in almost every federally owned building, everything with exclusive jurisdiction. It's a display of the laws of the land. As you know, the Declaration of Independence is in the center and it's raised, elevated. It's to indicate that this is the most important law of our land, and that the Constitution and the Bill of Rights on either side is subordinate to that. Now, the the Declaration of Independence, I've heard a lot of college students lately tell me that it's obsolete. I'm sorry, it is not obsolete, and further down this program, I will show the importance of it, or I will reiterate the importance of it. But the actual answer for this is going to be C, the Declaration of Independence, the Constitution, and all legal laws made under the Constitution. There is no Bill of Rights. Okay, the Bill of Rights was ratified in 1791. When it was ratified, it became part of the Constitution. Okay, so the first 10 amendments are now the Constitution. And this will actually become very important to understand as I go later on here and you see some other parts of this presentation, why that's important to know. So the second question I have is, what is a Constitution? What is the primary goal? Why? What is the goal of the Constitution? Well, the Constitution is a law. It is a law that is binding on every government official under its authority. It also delegates the degree of authority that is we have delegated to them, and it puts limitations to them. So if someone were to murder your child, would you expect that person to be arrested and tried and then go to prison? Of course you would. They've broken the law, right? They've committed a crime. How about if someone was to steal your car? Would you expect that person to be arrested, tried in a prison? Again, yes, they've broken the law and they've committed a crime. If someone was to arbitrarily beat you up, would you expect that person to be arrested, put on trial, and go to jail? Again, they've broken the law. They've committed a crime. So why then, if any official that is or agent that is under the Constitution, that is sworn to uphold the Constitution, like the President or Congress or the court justices and even our state representatives, were to violate this law, why wouldn't we expect to have them arrested, tried, and imprisoned? Okay? Now, rebellion is a crime. And if some person who is sworn to uphold the Constitution deliberately bypasses it or ignores it, they are in rebellion to that Constitution, are they not? And so, rebellion is most definitely a crime. If we take a look at Title 18, U.S. Code 2383, rebellion or insurrection. Whoever incites, sets afoot, assists or engages in any rebellion or insurrection against the authority of the United States or the laws therein, or gives aid or comfort thereof, shall be fined under this title and imprisoned not more than 10 years or both, and shall be incapable of holding any office under the United States. Now you notice it says against the authority of the United States. Is the President of the United States the authority of the United States? How about the Congress? Are they the authority of the United States? How about the Supreme Court? Are they the authority of the United States? They like to think so, but are they? The answer is no. We are a constitutional republic, and the Constitution is the authority of the United States. We are a country that is ruled by law. We are not ruled by people. We do not have leaders in this country. We have civil servants, but all too often we forget about this. And if anybody were to commit rebellion against the Constitution, such as a congressman, they're going to have to act together. They're also going to have the president's approval, so he's going to have to act as well. So there's going to have to be conspiracy between the parties, persons, Congress and the president and even the courts, to rebel against the Constitution. Conspiracy is this. Conspiracy is Title 18, U.S. Code 371, conspiracy. And it has this to say. If two or more persons conspire either to commit an offense against the United States or to defraud the United States or any agency thereof in any manner or for any purpose, and one or more of such persons do any act to effect the object of that conspiracy, each shall be fined under this title or in prison not more than 5 years. Notice that the term for imprisonment is 5 years, and that for rebellion the term was for 10 years. Any crime that you can be put in prison for a year or more is considered a felony. Any crime that you commit that's less than a year, that you can be sentenced for less than a year, is a misdemeanor. So both rebellion and conspiracy are felonies. Now, who can go to prison? Can the president? Can the Congress? What does the Constitution, since it's an authority, let's go ahead and see what it has to say. If we take a look at Article 4, Section 2 of the Constitution, it states that the president, the vice president, all civil officers, that's our Congress and the courts, and our Secretary of States and directors as well, all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, and or other high crimes and misdemeanors. High crimes are felonies. So here we see that it states shall be removed. This is not an option. This is mandatory. If they commit a crime, they are to be impeached. But impeachment's not going to prison, is it? It's not saying that they can be tried and go to prison. So we can have to look a little further and dig a little deeper and see what the Constitution has to say. If we take a look now at Article 1, Section 3, Paragraph 7 of the Constitution, it states this: judgment in cases of impeachment shall not extend further than the removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States, but, this is all important, that little word, but it's very important, but the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to the law. So you see, according to the Constitution, those the president, the Congress, and our courts, the judges in our courts, the Supreme Court justices and the lesser judges, have to go to prison for committing misdemeanors, felonies, treason, and bribery. Now, does this sound like double jeopardy to you? Because they can be both impeached and imprisoned? It's not. Double jeopardy is when you commit a crime, you're acquitted of that crime, and then the very next day they find a smoking gun that is proof positive that you did it. They can no longer come back to you and try you for that case. That would be double jeopardy. Now, are there any exemptions? You know, we've heard lately the president has said that he should have exemption for a presidential exemption from being looked at in different cases. Again, we need to take a look at what the Constitution has to say. If we look at Article 1, Section 6 of the Constitution, it states this: the senators and representatives shall, and notice it's talking about Congress here, senators and representatives. It's not saying anything about the president or judges, any of the Supreme Court or inferior judges. They shall, in all cases, except for, and the big word there, except, treason, felony, and breach of the peace, shall be privileged from arrest during their attendance at the session of their respective houses and in going to and returning from same. Breach of peace, of course, is a misdemeanor. Now, you notice there, they are still subject to arrest for a breach of the peace or a misdemeanor, a felony, and treason. So what is it that they are exempt from? What are they privileged from arrest from? Petty offenses, okay? They cannot be given a ticket for speeding. They cannot be given a ticket for illegally parking. They cannot be given a ticket for running a red light or a stop sign. They are exempt from those types of crimes, any petty offense. But they are still subject to arrest for misdemeanors, felonies, and treason and bribery. This is because they are meant to be held at the highest standard of ethical and moral behavior, not the least. Now, how about judges? We know that they are given an appointment for life. But what does the Constitution actually say about that? Let's go ahead and take a look at what the Constitution has to say. If we take a look at Article 1, Section 1 of the second clause, it states this: judges, both the Supreme and inferior courts, shall hold their offices during good behavior. Now, you notice how the word behavior is capitalized. That's the way it's done in the Constitution. Now, back in the old days, they did not have underline, they didn't have underscore, they didn't have italicized, and they didn't have bold. When they wanted to show that something was important, what they did, and to bring your attention to it, was they capitalized the first letter. Pretty cool, huh? So, what is meant by good behavior? We got to take a look at a little bit of history about the 13 judges who have been impeached. There's been 13 in the history of the U.S. Most of them have been impeached for bribery. However, one judge was actually impeached because he cussed inside his courtroom. He said swear words. And even though swearing is not a misdemeanor or a felony or any of that, he was still considered acting in bad behavior. He was impeached and removed from office. Another judge who was impeached, he was on his own time, doing his own thing. He wasn't in the courtroom. He was out having a good time, and he was found intoxicated within public. Well, they considered a judge being intoxicated in public as being bad behavior. So he was also impeached and removed from his office. So you see here, the clause is actually a double-edged sword for them. They can have a life appointment, but they can be removed at an even more delicate rate than a senator or a congressman or the president can. This is because judges who have the ability to try and convict a person have to be held at the highest ethical behavior They have to be an impeachable behavior. Okay? Now, can the president make a law? Can he make a law that is the law of the land, like an executive order? How about the courts? Do they have the power to make law? Can they make case law? We all heard of Roe versus Wade, right? Okay. Do they have this power? Again, we're going to have to go to the authority of the United States and see what the Constitution actually has to say about that. Oops, I went a little bit too far somehow. For some reason, I seem to be missing some slides. Oh, no, actually, I wanted to bring out a point here. And to bring out that point, I'm going to use a quote from Daniel Webster. Daniel Webster was a congressman. He was a senator from Massachusetts, and he was also a Secretary of State in the 1800s and mid-1800s. And he actually had this to say about the Constitution. It is hardly too strong to say that the Constitution was made to guard the people against good intentions. There are men in all ages who mean to govern well, but they mean to govern. They promise to be good masters, but they mean to be masters. This is the purpose of the Constitution. This is what it was all the reason we have a Constitution. The Constitution is designed to protect the people from the government. They protect you and I from the government. And that is why we have the Constitution. Now, let me go back now to, can the president make a law? Or the Supreme Court. And I'm going to take a look at what the Constitution has to say about that. If we take a look at Article 1, Section 1 of the Constitution, it states this: all legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. Legislative powers is the power to make law. How much of that power was given to Congress? All of it, correct? How much of it has been reserved for the president? None. How much of it has been reserved to the courts, the Supreme Court and the inferior courts? Absolutely none. Let's go ahead and take a look at what an executive order is right now. If we take a look now at Article 2, Section 2, Paragraph 1 of the Constitution, it states this: he may require the opinion in writing of the principal officer in each of the executive departments upon any subject relating to the duties of the respective office. This is what an executive order is. No more. You notice where it's directed. It's directed at the executive branch of government. It is directed towards executive officers within the executive branch. If a president declares an executive order to be the law of the land, and that would affect anywhere outside the executive branch, if it was to affect the people or even affect the states, he's actually violated this clause of the Constitution and Article 1, Section 1 of the Constitution. He is actually in rebellion of this Constitution, of these clauses, and he's committing a crime. He has no power to make laws. How about the Supreme Court? Do they have the power to make laws? Well, we're going to have to take a look again at the Declaration of Independence. Now, I told you that the Declaration of Independence is as viable today as it was when back in 1776 when it was actually put into law. There are the Declaration of Independence does 5 things for us. It gives us 5 powers, but I'm only going to address 3 of those powers. The first thing it does is it describes the nature of the character of this nation, how we were supposed to be. The second thing it does, it gives protection to one of our rights, and one of our most important rights. It is the first law that protects one of our rights. The third thing it does is it gives a list of reasons why people should abolish their government. Okay? Why people should separate from their government. So if we take a look at the Constitution, the Declaration of Independence right now. Oops, got too far. When in the course of human events it becomes necessary for one people to dissolve the political bands which have connected them with another, and to assume among the powers of the earth the separate and equal stations to which the laws of nature and nature's laws entitle them. Now, laws of nature, a lot of these secular people, liberals say that this gives a reason why this is a secular document. However, the laws of nature actually are referring to God. And my next, that right there, actually proved it, but I don't have time to actually go through it. But it is saying that it is a Christian and based. Okay. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, and among these are life, liberty, and the pursuit of happiness. That, to secure these rights, governments are instituted among men, deriving their just powers from the consent of the government. That, whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it, and to institute new government. So right there we see the two of the powers that the Declaration of Independence gives us. It states that we the people have delegated our authority to the government, okay? And that this is how it is supposed to be arranged in this government, or in this nation. That we the people are superior, and we are delegating that authority for them to govern over us. Notice something. Anytime you delegate authority, you're not relinquishing that authority. You can take that delegation back. And the second thing we see here is that we have the right to remove a government that is destructive of what's doing, that is violating the laws of their own of the land. Now, I'm going to have to continue on. I'm not going to go. Now, this clause right here, again, right in here, it reiterates the fact that we have the right to abolish it. Not only is it the right, but we have the duty to abolish it. So now I want to take a look at the part of the Declaration of Independence that gives us a list of the reasons why people should either alter or abolish their government, get rid of their present guards and go for new guards. And of course this is being directed at King James, or explaining what King James was doing. Or I'm sorry, King George III actually. He has, for abolishing, or wait a second, there we go. For abolishing a free system of English laws in a neighboring province, establishing therein an arbitrary government, arbitrary to mean arbitrate to judge, so it's a government of judges, an arbitrary government, and enlarging its boundaries so as to render it at once an example and fit instrument for introducing the same absolute rule into these colonies, for taking away our charters, abolishing our most valuable laws, and altering fundamentally the forms of our government, and for suspending our own legislatures and declaring themselves invested with the powers to legislate for us in all cases whatsoever. You can see here that judicial activism and case law are forbidden. That is what this is saying. Case law and judicial activism is forbidden. There are reasons for people to actually remove their government and institute new government. So anytime a judge makes case law, he is actually in violation of the Declaration of Independence and Article 1, Section 1 of the Constitution. he's committing a crime. It is a crime for them to render a case law. When they render a judgment, it is for the case before them and nowhere else. Okay? They cannot make law for themselves. What do we call a person who has the ability to make a law and carry out that law? Anybody know? Don't we call him a dictator? Okay. How about just a few people doing it? Wouldn't we call that a despotism? Isn't the purpose of us going to the war and the revolution, during the revolution, was to throw off a dictator and despotism? So why would we reestablish it again? They didn't. Oops, I think I went too far there. Okay. So, the judicial powers, what are the judicial powers? We just took a look at and said that they can't make case law, but maybe I'm wrong. Let's go ahead and take a look at the judicial powers, and if we do take a look at Article 3, Section 2 of the Constitution, this is where we find their powers. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the land. I'm sorry, I want to point out something. The judicial powers shall extend to all cases in law and equity. This is where our college professors and our congressmen and our judges stop. They don't actually continue on here. This makes it sound like they can hear a case on anything when they stop it there. This is a tactic they use more than once. But you notice here, it says, all cases in law and equity arising under this Constitution, the laws of the United States and treaties made or which shall be made under their authority. Remember, the Constitution is the authority. So it's arising under the Constitution. This is actually the second restrictive clause in the Constitution that limits the power of the federal government strictly to the Constitution. Okay? So now let's take a look at exactly what kind of powers our federal judges can hear cases on. Okay? Let's count them out. And by the way, if you see anywhere in this where they can make case law, yell out and let me know. Maybe, like I said, maybe I might be wrong. So if we continue on here, they shall make a law under this authority to all cases affecting ambassadors, public ministers, and councils. This means if an ambassador in a foreign land commits a crime, it would be the Supreme Court that would hear that case. So that is the first power that they have. The second power is this: the case to all cases of admiralty and maritime jurisdiction. This means if a crime is committed on the ocean or on the sea, the Great Lakes or the Gulf of Mexico, it would be the federal government that would hear the case on that. So that is their second power. So the third power is that they can have controversies to which the United States shall be a party. Okay? If you're wronged by the federal government and you want to sue them, you have to go before a federal judge and he will determine whether you actually violated something against the federal government, which is a pretty good gig. They get to say yay or nay. The fourth power that they have are to controversies between two or more states. So if the state of Missouri was to have a dispute about water rights with Arkansas, it would be the Supreme Court that would actually be the ones that try that case. So that is their fourth power that they have. The fifth power that they have is, well, you notice that the fifth one is in blue, okay? It states that between a state and citizens of another state. They no longer have that power. The state government took that power away from them. They took it away, the state governments took that power away from the federal courts. So the next, actually the fifth power is between citizens of different states. So if you ordered something on eBay for somebody in California and he did not send it to you, he just took your money and didn't produce it, you would have to take that kind of a case to the federal government. They would hear that case because it's two citizens from two different states. The next power they have, which would be the sixth power that they actually have, is between citizens of the same state claiming lands under grant of different states. Now that power is actually pretty much obsolete, okay? States aren't giving land grants anymore. I went to Alaska not too long ago trying to see if I could get one. They said, sorry, Charlie, no, we could do that a couple of years back. So then that was the last state that I know that gave land grants. So this is pretty much an obsolete power. So you can see, in reality, the United States Supreme Court and inferior courts can only hear cases on 5 subjects, those 5 subjects. Anything outside that, they cannot hear. Now, I told you that the state governments are the ones that took away the power from the federal courts. They did that by ratifying the 11th Amendment. The 11th Amendment states this: judges, the judicial power of the United States shall not be construed to extend to any suit in law or in equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state. It is the state government that took this power away. It is the state government and only the state government that can increase the power of the federal government or decrease the power of government. The United States Congress does not have the power to enlarge the power, their power, the power of the courts, or the power of the presidency, the executive branch. They don't have that power. It's not given. And that power that the states have, you'll find, is in Article 5 of the Constitution. Okay, that's where that is derived at. So let's say if you lost a case here in Missouri, you went to a court and you lost your case, could you appeal that case to the federal government? No, the federal government has no jurisdiction over such a case. How about if somebody from Arkansas was to lose a case here in Missouri? Could they appeal it to the federal government? Again, no. They have no jurisdiction. They have no jurisdiction over such a case. How about if they have someone from Canada comes down here, loses a court case, can they appeal it to the federal government? The answer again is no. They have no jurisdiction over such a case. And we'll go ahead and take a look, continue on with Article 3, Section 2 of the Constitution. And this is the remaining of that section where it states this: in all cases affecting ambassadors, other public ministers, and councils, and those in which the state shall be a party, the Supreme Court shall have original jurisdiction. That means they're the ones that hear the case, they try the case. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both to law and fact, with such exceptions and under such regulations as Congress shall make. So you see there, the Constitution only gives them appellate jurisdiction on the cases presented to them over those 5 topics, okay? They don't have appellate jurisdiction. The Constitution does not give them appellate jurisdiction anywhere else. Having said that, I want to take a look at the Judiciary Act of 1789. And the Judiciary Act states this: the Supreme Court shall also have appellate jurisdiction from the circuit courts and the courts of the several states, and in the cases herein provided for, and writs of mandamus to any courts appointed and persons holding office under the authority of the United States. I'm going to be addressing, hopefully I'll have time to address this a little bit further. It's a little bit further down, and I'll be explaining this in a little more detail then. But again, I make the assertion, even though it's an act of Congress, the act of Congress cannot enlarge the power of the Supreme Court. And we saw that in 1795, in the 11th Amendment, the power to hear cases from persons within a state was taken away from them. So Congress alone has the authority and the power to make laws. But do they have the power and the ability to make any law they want? Do they have any power to make anything they deem as necessary and proper? Well, right now, I would like to introduce you to Rob Nadelson. And I'm not going to introduce you to Rob Nadelson. I'm going to have this gentleman. He was the head of the Tea Party in Helena, Montana in 2007. And what you're seeing is clips from a Tea Party meeting where they invited Mr. Nadelson to the meeting to discuss the Constitution with us. So I'm going to let you find out his credentials through this gentleman right here. If I can get the thing to play.
Professor Rob Nadelson, leaving for Colorado, for a Colorado-based think tank. The way Rob sees it, his new job will be much like his old job, minus the captive audience. I guess my audience will be volunteers now, but otherwise I see myself continuing to teach, continuing to research, and continuing to take part in the public conversation, Nadelson said. Nadelson, University of Law professor at Montana since 1987, is leading to take a position at the Independent Institute, a Colorado-based think tank that promotes free market solutions to public policy issues. He has connections in Colorado, where he practiced law for about 10 years before turning to academia. Nadelson, who twice ran for governor of Montana, was very active in conservative politics for nearly 2 decades, has been affiliated with the Independent Institute since 1994. I did a study for them back when regarding some constitutional initiatives that were pending, and they published that study, Nadelson said. In 1998, Nadelson became a senior fellow with the Institute, and more recently elevated to senior fellow in constitutional jurisprudence. John Caldera, director of the Institute, said Nadelson's first project will be an analysis of U.S. Supreme Court cases over the years. Rob, student.
Okay, we can see right there by this introduction that Rob Nadelson is the guru of the Constitution. He's the person that teaches law professors what the Constitution means. So I'm going to go ahead right now and we're going to see what Rob Nadelson has to say about Congress and lawmaking abilities. Go back one more.
Which is Clause 18. Congress also has the power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers, etc. So to make necessary and proper laws. That is called, and it will astonish you to hear this, that is called the necessary and proper clause.
Okay, he called that the necessary and proper clause, correct? Let me tell you, there is no necessary proper clause anywhere in the Constitution. Necessary and proper is only verbiage within the clause. And you notice the way he said it. Let's go ahead and take a look at this, the actual clause that he just read. It's on Article 1, Section 8, Paragraph 18. And it states this: to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers. Notice he said etc. there. He ignores the rest of the rest of this clause. He ignores the rest of what it has to say. And this is the way we are taught in our colleges and our universities. This is what we're told by our politicians. This is what we're told by the media, that they can make any law that they deem necessary and proper. When you stop there, it gives them infinite amount of power. But let's take a look at what this passage, this clause actually states. It states, they shall have to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States and in any department or officer thereof. That vested by now narrows their power down to only what is granted to them in the Constitution. Okay? So if it's anything outside the Constitution, they can't make laws on that subject matter. The reason why I want to show you this is I'm showing you a way in which our government circumvents the Constitution so they can commit rebellion without you being wiser. This is the first way they do it, and I call it the clause con. Okay? They make clauses where there are no clauses. Another clause con is the welfare clause in the same section right here. There is no welfare clause. Again, it is verbiage within a clause. So that's the first way in which they circumvent the Constitution. I'm going to show you two other ways that they go about circumventing the Constitution. We're going to take a look now at a case. McCulloch versus Maryland in 1819. This was rendered by Chief Justice John Marshall. And this is what he had to say. The first question made in this cause is, has Congress the power of incorporating a bank? The power, now contested, was exercised by the first Congress elected under the present Constitution. The original act was permitted to expire, but a short experience of the embarrassments to which the refusal to revive it exposed the government, convinced those who were most prejudiced against the measure of its necessity, and induced the passage of the present law. This government is acknowledged by all to be one of enumerated powers. The principle that it can only exercise only the powers granted to it is now universally admitted. 175 years ago, this was common knowledge. Every person in the United States understood that Congress could only make laws that was granted under the Constitution. 175 years ago, our congressmen and our president understood that Congress could only make laws within the Constitution. It was so universal that even the nations that we actually do business with and trade with, they also knew that Congress could only make laws that were defined within the Constitution. They were enumerated acts. Like I said, that was common knowledge back then. Today, that's pretty much an enigma. We don't understand it. I'm going to go ahead quickly and go through this. Usually this case right here, I usually take about 20 minutes because there's so much stuff in here. There's so much information in here that people should know about. Okay? But I'm going to go ahead and go down to where it says almost. Almost all compositions contain words which, taken in their rigorous sense, would convey a meaning different from that which was obviously intended. In the 1960s, Judge Hugo Black, not Chief Justice, just Supreme Court Justice Hugo Black, was interviewed by Walter Cronkite. And when he was asked about the Constitution, Hugo Black said this: "The Constitution is a literal document written by men who knew the literal meaning of the words. Of course, that's how it has to be." So what he was saying here when he made his opinion right here, where it was that meanings different from what they obviously are intended, what he is doing is misinterpreting the Constitution. Misinterpreting and just ignoring the Constitution are another way in which our government circumvents the Constitution so they can commit rebellion without you being all the wiser. The third way they go about doing this is I'm going to have help with that by Mr. Nagelson all over again.
If you put those two powers together, the power to regulate commerce and the power to make necessary and proper laws, you come up with what we constitutional law professors affectionately call the commerce power. Now, what does the commerce power mean? Well, let's focus on the part of the commerce power that is currently or most often used by Congress in passing legislation. The power to regulate commerce among the several states. What that essentially means is the power to regulate trade from state to state. So if goods are being transported from Montana into Idaho, Congress has the power to regulate that transport. It has the power to regulate the train or the plane or the truck in which they're carried. It also gives Congress the power to regulate travel of people from state to state. And it gives the Congress certain incidental powers, particularly under the necessary and proper clause. For example, Congress can regulate the transportation of new clothing from state to state, and maybe also can require proper labeling. That's a great deal of power. In the 1930s, we had a very terrible economic depression, as you know. And under the prodding of the administration of Franklin Roosevelt, Congress passed legislation that far exceeded in scope anything Congress had ever passed before. Some of this legislation was struck down by the U.S. Supreme Court as being outside of Congress's power. But eventually, advocates for the Roosevelt administration were able to argue that virtually any regulation of the economy could be justified under the commerce power. So there was a bit of a constitutional revolution in the 1930s and early 1940s, so that this limited, important but still limited power to regulate trade and certain incidental activities became in the hands of the Supreme Court a power virtually to regulate the entire economy.
Okay, you see there, the Supreme Court goes about circumventing the Constitution again, this time by redefining words. They gave a new definition to the word commerce. So this is another way in which they circumvent the Constitution so they can actually commit rebellion against the law of the land. Now, I'm going to show you another clip of him, and there's so much actually in here that I normally talk about when I have my 2 hours or more than 2 hours. There's just so much that is said in there that to be discussed, and how they go about doing it, and how they went about circumventing it, and how it all came about. But I want you to listen to this, and then I'll confirm what I just said about
Commerce Clause, Congress clearly has the power to regulate the transport and the terms of the passage of the clothing from state to state. Under the necessary and proper clause, Congress has the power to insist that the labeling of products that go from state to state be honest and not deceptive. That's pretty much as far as the Commerce Clause and the necessary and proper clause go, at least according to the original understanding. Under the New Deal cases, Congress says, well, you know, under the necessary and proper clause, we can not only regulate the transport of the clothes and the labeling of the clothes, we can regulate the clothes manufacturers too. We can regulate the folks who make the clothes even if they're only within one state. And that is in fact the current law of the Supreme Court. This Constitution was written for a relatively small government. It was not written for a government that controls 30-some-odd% of American gross domestic product. Okay? And so when people complain about the unresponsiveness of Congress, or the arrogance of bureaucrats, or the level of the taxes, or whatever, you have to keep in mind that this is largely a product of the fact that we have taken a form of government that's designed for a mostly free people and and change it into a government that regulates virtually every aspect of our lives. I mean, that is not what the government was set up to do. So you get all kinds of problems.
So you can see again, the Supreme Court made a law that commerce would not only mean the transportation of goods, which was, if you take a look at the original definition, that's all it meant, to actually now manufacturing. So that way they increase the power of Congress and that circumvent the Constitution. Now, notice where he said that our government now regulates 30% of the economics. That was back in 2007. Right now, it's probably closer to regulating 45 to even 50%. Knowing this, what form of government is the United States? What kind of government are we practicing here in the United States? Does anybody know? Please be honest. Are we a democracy? Are we a constitutional republic still? Are we a communism? Or are we a fascism? What we're practicing in this nation is fascism. The government is controlling what we do. We're controlling our economy. And the fascism that is actually being practiced in this country is closer resembles what Nazi Germany did in the 40s and less like what Mussolini did. Mussolini was a little freer. So right now, because of what our Supreme Court has done, we are really no longer a free people. Now, so Congress has the power to make laws, correct? Let's see what that power entails.
Under the Commerce Clause,
That we are citizens of an American nation, and our rights are being threatened by a tyrant 3,000 miles away.
Would you tell me, please, Mr. Howard, why should I trade one tyrant 3,000 miles away for 3,000 tyrants 1 mile away? An elected legislature can trample a man's rights as easily as a king can.
There has never been a truer statement that ever came out of Hollywood. You cannot remain a free people if you have full-time professional congressmen, legislatures. It cannot be done. There comes a point in time, especially when you have a constitution and they have such limited power, when they make all the laws necessary. But if you have a full-time profession, you have to make laws to justify your existence. So sooner or later, you're going to have to usurp the state's authority. And once they usurp the state's authority, they're going to have to make laws that will start to restrict us more and more and more. Just like we saw in the previous slide with Professor Nadelson. You cannot, it is impossible to remain a free people when you have full-time professional legislators. Let's take a look at what power was actually granted our Congress. To do so, we got to take a look at Article 1, Section 8 of the Constitution. The first thing it states is this: the Congress shall have the power to lay and collect taxes, duties, imposts, and exercises, to pay the debts, and to provide for the common defense and general welfare of the United States. But all duties, imposts, and exercises shall be uniform throughout the United States. There are 2 clauses in there, and only 2. But you notice the word welfare in there. Our Congress uses that as our welfare clause. Again, it is merely verbiage within the clause. This is a clause for taxation. The next 17 clauses, actually 16 clauses, deal with what they can tax us for and what our taxpayers' money can go to. Anything beyond this is actually in rebellion against the Constitution, because they are limited strictly to what was granted here in the Constitution. So, to borrow money on the credit of the United States, they are to pay off the debts. Right now, with $1 trillion worth of debt, do you think we could ever pay that off? So every time they increase the debt, national debt, and everything like that, they're actually in violation of the Constitution. They're actually committing a felony again. Now I'm going to go through these very, very quickly. I'm not going to go through them as in detail until. The next 8 clauses are what is described for general welfare. These are the general welfare clauses, and this is what is meant by that term. To regulate commerce on foreign nations and among the several states and with the Indian tribes. Nato Sim covered that. We just looked at it. So we'll go on. To establish a uniform rule of naturalization and uniform laws on the subject of bankruptcies throughout the United States. 3, to coin money and regulate the value thereof and of foreign coins and to fix a standard of weights and measures. 4, to provide for the punishment of counterfeiting the securities and current coin of the United States. 5, to establish post offices and post roads. To promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and inventions. 7, to constitute tribunals inferior to the Supreme Court. And 8, to define and punish piracies and felonies committed on the high seas and offenses against the law of nations. One thing I do want to go back to and take a look at is the second clause there, where it says to coin money. And the fourth clause, it also says that to punish for counterfeiting of the current coin of the United States. In Article 1, Section 10 of the Constitution, it states that only gold and silver may be used as currency in the United States. It also states that no bills of credit may be emitted. No president and no Congress can change the Constitution. Only an act of the states in ratifying an amendment can do so. So that fiduciary money, bills of credit are like your fiduciary money and your fiat money. The fiat money is the money you have now in your pockets and in your purses. That money is illegal and is actually worthless. Okay, it has no true value. The value is an illusion because we are told it has value. Also, the national debt is a debt on the fiduciary money. Wouldn't that also be an illusion as well? I think so. But we still have to pay it. So the next 6 clauses are defining what is meant by common defense. Let me get to that. To define and punish piracies and felonies committed on the high seas and offenses against the law of nations. I'm sorry, that's the next things. The first one is to declare war, grant letters of marque and reprisal, and make rules concerning captures on land and water. 2, to raise and support armies, but no appropriation of money for that use shall be for a longer term than 2 years. 3, to provide and maintain a navy, an air force, and space command. 4, to make rules for the government and regulation of the land and naval forces. 5, to provide for the calling forth of the militia to execute the laws of the Union, suppress insurrection, and repel invasions. 6, I got it for you. I'll do this. To provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States, reserving to the states respectively for the appointment of the officers and the authority to training the militia according to the discipline prescribed by Congress. Now, you notice here where it says that the part of them as may be employed in the service of the United States, and if we go back to if we go back to where it says to provide for the calling forth of the militia to execute the laws of the Union. If we take those two, did President Trump have the authority and power to call the National Guard? And the National Guard is our militia, okay? That is what the militia is our National Guards. Did he have the power to call the National Guards to suppress the riots in California? Can I see a show of hands how many think he did? I've got a few hands, okay? That was a trick question. I'm sorry, the answer is no, he did not have the power. He was actually in violation of Article 4, Section 4 of the Constitution. It really helps to know the full Constitution when making decisions like that. And I honestly believe that when Trump was given advice from his advisors, this is what they showed him. And this is what he made his decision on. They did not show him Article 4, Section 4, where it states that the only way that they can have the National Guard come in is on petition by the state legislature. Okay? That's the only way federal government can get involved with a state government is through a petition by the legislator or the executive when the legislation is not around. This is the 17th clause of Section 8, and it states, to exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square. So it's not infinite amount of power again. It's refining it down to just a district that they're allowed to have. As made by cession of particular states and the acceptance of Congress become the seat of the government of the United States, and to exercise like authority under all places purchased by the consent of the legislator of the state in which the same shall be, for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. Does anybody see there where Congress can obtain lands through an act of Congress? Does anybody see that there? It's because it's not. An act of Congress cannot obtain land from the states, not even when it's allowing that state to come into the Union. The only way that the federal government can obtain lands is through cession and by purchase. How many of you here know what cession is? Can I see hands? One person? Okay. Cession is a treaty. It is a treaty between two governments. One government that formerly owned land and the second government that has the land now. And what it is they're making a treaty so that the government that had to have land can have a part of that land again. That is what a cession is. It is a treaty. So it's the federal government making a treaty with the state government to obtain land, to obtain some of that land back. And they can get that land back for what? What purposes? Okay, now, but that being said, I got a question for you. Does the federal government have eminent domain? Yes, they think they do. But according to this, the only way they're going to obtain land is through cession and purchase. That means they do not have eminent domain. That means any case that the Supreme Court hears on eminent domain is in violation of this clause right here. They are committing rebellion and they're violating the Constitution. They are actually committing a crime. And notice what it says they can actually get land for. They can do it for forts, magazines, arsenals, dockyards, and needful buildings. Okay? Forts are your Army bases, your Air Force bases, if that was actually legal, and Space Command bases, if that was actually legal. It's also for the magazines and arsenals. That's where we store our tanks and our Jeeps and things of that nature, or Humvees, and arsenals are where we store our ammunition, our guns, and the powder and everything like that. And dockyards, of course, are naval bases, and then needful buildings. Needful buildings would be a building where they can have post office, right? The post office would need a building. That would be a needful building. They can have a patent, make patents. They need a patent office. They need a building. That would be a needful building. So the needful building describes the clauses, the powers that were just talked about. That's what that's for. Does anybody see there where they can have national forests? How about national parks? How about land for national scenic waterways? How about land for BLM lands? Is it there anywhere? Anybody see that? Then where do they get that power from? Where can they obtain that from? They can't. Every one of those land parcels, land properties are illegal. The federal government cannot do that. They have usurped the state's authority. They have taken the state's land from them, and they're not allowed to. So that is basically all the power that the Congress has power to make laws on. Now there are a few amendments. The few amendments of the 13th Amendment, they can make laws on issues of slaves. On the 16th Amendment, they can make laws regarding taxation, income tax. And then Amendment 15, 19, 24, and 26 is what they can make laws on voting. Voting for women's voting, for voting on concerning race, voting age of 18, and no taxation. That pretty much covers all the power that the federal government can make laws on. And there's a couple other amendments that they can, but a lot of them are, again, pretty much obsolete. As I said, Congress has no power whatsoever to make laws that would increase their power or decrease their power. Okay? And I'm going to show you a little proof on that I'm not making that up. One more. And of course, we've already talked about the 18th clause on the 18th clause of Section 8. That was the one that said that they have the power to make laws on the Constitution. We did that one first. So right now, I want to go to, take a look at this case. This case is Marbury versus Madison. It was heard by John Marshall, Chief Judge Marshall. In this case, he had just been elected as the Supreme Court Justice. So his feeling on the law was actually still pure. He had not been corrupted at this time. In McCulloch versus Maryland, by that time, I talk about the corruption in that case. But this time, he was still, his love for the law was still pure. And this is what he had to say in this case, Marbury versus Madison. It is emphatically the province and duty of the Judicial Department to say what the law is. Those who apply the rule to a particular case must, of necessity, expound and interpret that rule. If two laws conflict with each other, the courts must decide on the operation of each. So, if a law, an act, a statute, or treaty be in opposition to the Constitution, if both the law and the Constitution apply to a particular case, so that the courts must either decide the case conformably to the law, disregarding the Constitution, or conformably to the Constitution, disregarding the law. The court must determine which of these conflicting rules governs the case. This is the very essence of judicial duty. If then the courts are to regard the Constitution, and the Constitution is superior to any ordinary act of the legislature, the Constitution and not such ordinary act must govern the case in which they both apply. Oops, I actually read that one without you guys being able to see it. Read along. Sorry. Those then who controvert the principle that the Constitution is to be considered in the court of paramount law are reduced to the necessity of maintaining that the courts must close their eyes on the Constitution and see only the law. This doctrine would subvert every foundation of all written constitutions. To what purpose is our powers limited? And to what purpose is that limitation committed to writing? If these limits may at any time be passed by those intended to be restrained. Certainly, all those who have framed the written Constitution contemplate them as forming the fundamental and paramount law of the nation. And consequently, the theory of every such nation must be that an act of the legislature repugnant to the Constitution is void. So you see, if Congress had the ability to increase or decrease their power, decrease the power of the president, or increase or decrease the power of the, well, they can actually put restrictions on the judicial branch. But if they had that power, what value would be at the Constitution? It would have no power. No power whatsoever. I've been doing this for an hour and 13 minutes. Do I have time, or do you want me to go ahead and quit now?
Depends on how many questions and answers. I was going to get you in about 8 minutes.
Okay, in 8 minutes, I might be able to cover what...
Are there a lot of questions so far? Who thinks they might have a question a little bit?
Well, good. Then I have time to go ahead and... Let me go back.
What's your take on the Fourth Amendment, Article 4?
This is going to be Nadelson again.
State or full faith.
This is state rights I'm talking about.
States for the public acts. What is your take on the public acts, and how does that affect as far as like healthcare and things of that nature?
Article, those of you who know the Constitution know that Article 1 deals with Congress, which makes the law. Article 2 deals with the Supreme Court, which enforces the law. Article 3 deals with the courts that adjudicate the law. And Article 4 is a collection of clauses that are designed to make us a more perfect union. And by the way, the word perfect here has a specific 18th century meaning. Perfect in the 18th century usually didn't mean without flaw. Perfect meant complete. So a more perfect union is a more complete union, and that's what Article 4 is largely about. And you can see Section 1 is called the Full Faith and Credit Clause. Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. And the Congress may by general laws prescribe the manner in which such acts, records, and proceedings shall be approved and the effect thereof. Basically, that is it's a housekeeping measure. If a judgment against somebody is entered in Colorado, then that judgment can be transferred to Montana and enforced in Montana. If there's a child support decree that's entered in Wyoming, again, that can be enforced in Montana. If there is a marriage which is valid in one state, it can be proved in another state. That last part has become quite controversial, as Massachusetts, for example, has recognized same-sex marriage. Does this mean that under the Full Faith and Credit Clause, other states have to recognize same-sex marriage too? Well, Congress passed a law when President Clinton was president that said no, other states don't have to recognize that. I suspect the constitutionality of that law will be challenged. So that's really what the Full Faith and Credit Clause is about. It doesn't really have any big overarching significance other than I think in the area of marriage. It's largely a housekeeping issue.
Okay, he's saying that Article 4, Section 1 is basically a housekeeping bill. It doesn't have any significance. Is our guru of gurus even close to being right? I'm sorry, no. He's not even close. This is let's go ahead and take a look at Article 4, Section 1. Full faith and credit. That's an vernacular we don't use very often. What does it mean? It means all authority. So what they're doing is they're giving all authority to the states here. Full faith and credit, all authority shall be given to each state in the public acts. Notice that acts is capitalized. That's because it's important. Notice where the comma is. So what are public acts? Any laws that deal with people, that's you and me. That is, we are the public. So they have the authority to make laws concerning the people. Next thing are public records. Now I've noticed you guys were talking about the real ID here. Do they have the right to enforce the Americans to have the real ID? The answer to that is absolutely not. They have to take a look at the state law, record, and they have to acknowledge it as proof that you are a citizen of that state, which means you're a citizen of the United States. Now, he kind of got judicial proceedings fairly close until he got the thing of marriage. Now, how many people, when they go get married, they go against the judge and says, you are now hereby sentenced to life with this lady, and lady, you're hereby sentenced to... It's not a court case, okay? You can get married by a pastor, a preacher, or anybody else, or whoever has the authority. So it's actually not a judicial proceeding. If you do have like a child support decree against you, yes, he was right there. If you go to Montana and from trying to escape a child support, you're going to have to pay it in Montana. Montana will force you to pay it. But everything else he got wrong. The states have, this clause is actually giving the states an infinite amount of power. Now, how can I know that I'm right when I'm telling you here, and that the federal court, the federal judges, the universities, the colleges, and even the high schools are wrong about this? Well, how many of you know who James Madison is? James Madison was one of the authors of the Constitution. You think maybe he would know what the Constitution had to say? Not only did he help write the Constitution, but he helped write a series of articles called the Federalist Papers. And these Federalist Papers were published in a national paper so that all Americans could see what was going on. And they were trying to convince the people that the Constitution was a good thing. Most people were against it at first, but they didn't understand it. So this is what James Madison had to say about the powers. The powers delegated by the proposed Constitution to the federal government are few and defined. Those which are to remain in the state governments are numerous and indefinite. The former will exercise principally on external objects as war, peace, negotiations, and foreign commerce, with which the power of taxation will, for the most part, be connected. The powers reserved to the several states will extend to all objects which, in the ordinary course of affairs, concern the lives, liberties, and properties of the people, and the internal order, improvement, and prosperity of the state. The operation of the federal government will be most extensive and important in times of war and danger, those of the state government in times of peace and security. Notice how much power he was giving the state government. Where is that found in the Constitution? He's referring to the Constitution. This is the only clause in the Constitution that is giving him that type of power. So what Professor Nadelson has said up there, and what most constitutional law professors tell you, is absolutely incorrect. And the evidence is how the Constitution is written, how this clause is written, and what the man who wrote the Constitution has to say. So right now, I am going to go ahead and stop this. My next part would be on our rights, what rights are, and but that's going to take a little bit more time. We've been already doing this for an hour and 21 minutes. Are there any questions of what I've just covered? Go ahead, ma'am.
So Mike Lee was talking about using federal land to make into affordable housing. Mike Lee was talking about using federal land for low-income housing. He was going to beautiful bill. He took it out, but is that something that he could even get started? I mean, it doesn't sound like, you see what I'm saying? I mean, how can you sell something that the federal government shouldn't have? But they have it.
There's the answer right there. The federal government does not have the right for land, BLM land, or any other federal lands within a state. The only lands they would have would be on a air base, a naval base, a army base, things of that nature. And I don't think our military would be willing to put housing on their bases. Okay? So legally, it's a moot point, because the federal government isn't allowed to have land for those purposes. What we have to do is we have to put the proper authority back on the states. We have to get them to take their power back. When we had the Constitutional Convention, when we had the caucus, Republican caucus in Texas County, I introduced a proposal that the state governments could make a state law, and the state governments could actually take back all the power they needed from the federal government. I believe Senator Moon put in a bill that was similar to what I proposed, but it went nowhere in state government. When it went to Congress, it didn't go anywhere. The states have to take their power back. And the states could actually set aside land for low-income housing if they wanted to. That's their power. When it's dealing with the people, anytime we're dealing with the people, it's the responsibility of the state. Why is that? Can anybody understand why the state government was given that power and not the federal government? Go ahead.
They're closer to the people.
Absolutely. We can control the state government much better than we can control the federal government. With the federal government, they're kind of an ambiguous organization out there. You know, yeah, we might go to the IRS office, we may even go to the Social Security office. But for the most part, they're ambiguous. How many of you actually have talked to your state representative or actually talked with your state senator? In this group, I'm expecting that we did find a couple. But very rarely do we get to do this. We might have a chance, our state representatives most likely will come out and talk to you. I know Benny Cook in our district, he comes out a lot. When we have a function, he's usually there. We can actually talk with him. So we have the opportunity to talk more readily with them. The people can control the state government better than they can control the federal government. This is why the bigger the government it is, the more obscure it becomes to the people. And if we're a nation for the people, by the people, then we have to have limited power. The higher the power goes, okay? The more power the thing gets. The federal government needs to have the least amount of power. Our state government, as it was given in the Constitution, and as we saw by James Madison, the state has it because we can control them. We can actually go to the Capitol much easier than going to the Capitol of the United States. Any other questions? Go ahead.
Can I ask another one?
Sure.
So, where in our Constitution does it say what will happen when our debt is called in by our debtors? Is there something in the Constitution that says what will happen? And one prominent talk show conservative said that they could possibly call in on our federal land, which then we would have to give to them that they would then own. Is that bogus?
That's bogus. Okay. First off, there's no federal land. They want to take our military bases again. There is no federal land. It's state land. Secondly, the national debt, the vast majority of it is interest. Did you know that?
Right.
The vast majority of our national debt is interest. How can you earn interest on money that is illegal? Will someone please inform me how that happens? No. I told you that the national debt is an illusion. It's because the money we carry and use is an illusion. Gold and silver is the only currency that is permitted in this nation, okay, legally. We got away with that. Got away from that because people were scared. They had the Depression, and we had somebody who was more than willing to rob the people and take more control than they had. Franklin Roosevelt, to me, was the biggest traitor this nation has ever seen. He is also the biggest theft. Do you know he had an executive order requiring the people to turn over their gold? Okay, you know, he had no power to do that. Now, he was supposed to give certificates so people could get their gold back. Did the federal government ever honor that? Remember, I was in the state Mint police officer at Denver Mint. I've seen all our gold. Piles and piles of gold. All that gold was taken from the people during the Franklin Roosevelt time. Okay, big, beautiful blocks just sitting there. And I'm not even sure they're sitting there. I had friends there. Matter of fact, my mother-in-law was there. And she said one day, some trucks came in, a lot of security in there. J-Vault with gold was open, and nobody knows what happened after that. So that is what I was told. So I don't know what we have down there right now. Go ahead.
Do you think there's gold in Fort Knox?
I don't know anymore. Like I said, I don't, you know, those who have the national debt and are earning all this interest might have said, hey, we want this gold as collateral. I don't know. I'm just assuming. An assumption. You know what happens when you assume, right?
Yeah.
Okay. So are there any other questions? Go ahead.
President Trump recently ordered the removal of illegal aliens. However, some courts decided, no, he doesn't get to do that. So the question is, did he really have the authority, or were they usurping his just out of dislike for him?
As we read, the federal government has jurisdiction over immigration. Okay, that is in Article 1, Section 8, and paragraph number I think it's 3. It's number 2 actually. Well, 3 clause, but it's the second clause where it says to establish uniform rules of naturalization. That is our immigration laws. There are already immigration laws in place. The immigration laws say that a person coming in here illegal will be deported. So yes, if Trump is following those immigration laws, the Supreme Court, no other court has the power to say otherwise. Their job is to uphold the law, or uphold it. It's Trump's job to enforce it in my book as well. Another way that I have just actually written up, and I'm actually trying to produce, is, or try to get out there, is I have put a proposal that the American people vote to have a tribunal that would have the power to apprehend and arrest any member of Congress, the president, or the courts that are required to support the Constitution under oath and are violating it. They would have the right and the power to arrest and try and sentence for rebellion, conspiracy to commit rebellion, bribery, and contempt of court. We have the power to do that. We actually have the power. We don't have to actually rely upon the government to allow us to do that. I mean, if we tried it without this president, I think Trump is the only time in our history, our recent history, that we would be able to do something like this. Where the people would say, hey, look, we are going to invoke our right guaranteed to us and protected to us by the Declaration of Independence. And we are going to make a tribunal giving us the authority to control your lawmaking ability and what you're doing, your abuses of the Constitution. That is another way that we can actually take back our country and become a free people all over again. That's a long shot, I know. I just got the proposals out. You're probably one of the few people who have actually heard about that proposal. I've done it a couple of other people that I've shown this proposal to. Some are skeptical, and I don't blame them. I mean, it's a radical proposal, but everything I put in there is lawful. and it's not insurrection. Okay? Where I'm not talking about overthrowing the government, I'm talking about enforcing the Constitution, the laws of the land. The authority, remember, is the Constitution.
So that has come up several times and in our meetings, because on a local basis, we have in our county elected who are not upholding their oath of office. And that is in the Missouri Constitution.
Okay.
But we have, even if a citizen, I mean, we would be laughed at, right, if we went up to our Mark Welker, our prosecuting attorney, because he's not upholding his oath to take to libraries. You guys have talked, we've talked about libraries for the last couple of years, the pornography in libraries. And so we have pressured and pressured just for that, but the prosecuting attorneys will not even take that up. So I don't know how, I mean, yes, it's all there, we are backed, I mean, we have this, but it's not, I don't see how it's gonna be realistic. What are we gonna do? If we all of us go to arrest whoever is elected, right?
Well, like I said, to establish a tribunal and make it lawful. When I said establish a tribunal, I mean that it would be presented before the people. The people would take a national vote to determine whether they wanted this tribunal or not. And when they did, in my proposal, I actually outlined a law. Okay, I made it into law form, just like you would any other law. And in the law, just like the Constitution was when it originally was proposed in 1789. In the proposal that I put in there, it would become part of the Constitution, but separate from the government, okay? It would be by the people. The people would be the one to do it. In addition to putting a tribunal, and I put a certain number to make it so that it did not become a bureaucracy, I put limitations on it. I put safeguards in there. I put one of the safeguards is the number of people that would be on the tribunal or operate in the tribunal. You'd only have so many professional, actually I chose to have professional jurors. There would only be 3 judges. They would have a grand jury. The grand jury would be made up, have about, I think I put like 20 people in it, only about 20. And then we'd have investigators, we would have bailiffs and things like that, so that the whole tribunal would be a self-contained unit, but only put so many people that could do it. The second thing is I put term limits on how long the judges, the jurists, and how long the grand jurist could actually stay in there. I put term limits, and it's only 1 term for 6 years. I think that after 6 years, corruption is guaranteed. Then a couple other things I put in there was how they receive money. The only way they would receive money is not through taxation, but through the fines of those who are convicted. So it would basically almost be a voluntary thing, and those 60 people, and I think it was enumerated only 60 people. Like I said, I did not want this to become a bureaucracy. And again, the last thing I did was made it so that they only had power over 4 laws. Okay, they can't, no more power over any other type of law. Those 4 laws. This way it would prevent it from becoming another bureaucracy that we'd have to monitor and get another group to monitor them. But in that thing, I also said that each state should have their own tribunal to enforce their state constitutions. And again, it's totally legal. Our Declaration of Independence gives us this power. It not only guarantees us this power, but it considers it our duty. So that, I hope that answers your question right there. Yes?
Oh, I agree with you,
Yeah?
but when you say we have to vote for this, how realistic is it to think that we can really do this? Because you see how much in our elections, the propositions and amendments we try to get done that's right, that we can't get passed.
That's what I'm saying. We're going to have to keep it out of the hands of the politicians. Somehow we're going to have to get organizations, kind of like this Guardian, possibly schools that are Christian-based, let's say talk social hosts or other known individuals who are promoting the Constitution to get the word out. And then when we do it, we're going to have to get maybe school boards that will open up their doors and then have just an election. It would be difficult. Yes, it would be difficult. And I'm not saying, like I said, I got a lot of people who read it and said it doesn't seem very practical. I said that so. But we got to try. And if you don't try, nothing's going to happen.
That's
Any
a
other
defined
questions?
tribunal. Defined tribunal.
A tribunal is a court that has specific and limited jurisdiction. That's all a tribunal is. A tribunal is just a court that has specific and limited jurisdiction over whatever. Like for this, it would be over the federal government, the politicians who are sworn to uphold the Constitution.
Perfect timing.
See?
Time to end the meeting. You did it. You did it.